The trunk arrived on a Tuesday in March, and nobody in the room thought it was worth the $14 Arden had paid for it. He was 30 years old. He had $1,142 in his checking account, a part-time position cataloging estate papers for a historical society in Galveston, Texas, and a studio apartment that smelled, faintly and permanently, of the previous tenant's cigarettes. The woman at the estate sale had quoted him $14, not because the trunk had value, but because she wanted it gone before the rain came. The mockery started at the Historical Society the next morning. "You bought that." This from Denny Pruitt, who managed the reading room and had opinions about everything that came through the door. He said it the way a person says the word mold. $14, Arden said. Denny looked at the trunk the way a man looks at roadkill that has somehow followed someone inside. It sat on the intake table under the fluorescent light, a dome-top steamer trunk, roughly 32 inches long, covered in what had once been black vulcanized fiber, but had since oxidized to a color that existed somewhere between green and exhaustion. The brass hardware had gone the color of a winter sky. A paper label on the lid, not a sticker, read Harriman and Morse Transfer, Galveston, with a date Arden had already read 4 times. September 1939. "It smells," Denny said. "Old paper smells. That's not paper. That's 80 years of somebody's bad decisions." The Society's director, Patricia Holst, walked through on her way to a donor meeting and stopped. "You're spending $9 an hour time on $14 worth of personal property. I'm taking my lunch break early," Arden said. Holst left. Arden stood alone with the trunk and the smell of old paper and something else, something mineral and faintly mechanical, like the inside of a clock that had not been opened since before he was born. He pulled on his cotton examination gloves. He was not looking at the lock first. He was looking at the exterior labels. There were 3 of them, layered, oldest beneath the others, and the bottom edge of the deepest one had lifted slightly near the left hinge. Through that gap, if you angled the light correctly, you could see the corner of something printed on the concealed label's reverse side. Numbers, not a serial number, not a shipping weight. A column of numbers, formatted like a ledger, pressed into the underside of a label that someone had deliberately covered with 2 subsequent labels and then lacquered over. Arden picked up his loop. Then he looked at the lock. It was a 4-tumbler brass mechanism, recessed into a stamped housing, and someone had replaced the original key plate. The screw holes didn't align with the original impressions in the fiber. Someone had rekeyed this trunk deliberately, not repaired. Rekeyed, a trunk made to look worthless, a lock changed after the fact, a label hidden under 2 others. He did not say any of this aloud. 3 weeks before the trunk appeared in his life, Arden had driven 4 hours to Beaumont for the reading of his great-uncle Clement Farrow's will. He had not known Clement well. The man had been 89, a retired postal clerk, living in a house that smelled of Bengay and back issues of National Geographic. Arden's family had visited perhaps 6 times in his entire childhood. Clement had seemed more interested in Arden than in any of the others. He had once sat with 8-year-old Arden for 2 hours, discussing how postmarks could be used to date correspondence. But Arden had assumed this was the preference of old men for quiet children. The will reading took place in the offices of Garrett Lyle, an attorney who wore a Patek Philippe watch and had the particular stillness of a man accustomed to other people's grief being profitable. Now, Lyle's cufflinks were monogrammed. His suit was charcoal cashmere, the contrast with Arden's department to minimize the other heirs. Arden's cousin Brent, 40. Cousin Brent, 44, who ran 3 car washes and attended every family gathering wearing expressions of mild contempt, and Brent's mother, Sheila, Clement's niece by marriage, who had coordinated Clement's final 2 years of care and expected compensation. Clement's estate totaled $217,000. Brent received the house, appraised at $161,000, and the savings accounts totaling $44,800. Sheila received the pension residuals. $11,200. Arden received a trunk. The will's language was precise. One dome-top steamer trunk, black vulcanized fiber construction, brass hardware, manufactured approximately 1930 to 1935. In my possession since 1963. Contents intact and untouched. Per my specific suitcase, Brent said. He left you a suitcase. Not cruelly, exactly. The way a person states a fact that is also an insult. Contempt disguised as observation. You drove 4 hours for a suitcase. Arden signed the transfer documents without answering. You're welcome to have the trunk appraised, Lyle said, in the tone of a man who expects the appraisal to confirm his own assessment. If the contents prove to be of value, there are provisions in the estate documentation for contesting the distribution. I'm sure there are, Arden said. He carried the trunk to his car alone. It weighed 31 pounds, heavier than he had expected for something so hollowed-looking. He noted that, and did not note it aloud. The label beneath the labels read in Arden's loop, Whitmore correspondence, trunk 7 of 9, not for transfer, R.H. He spent 4 days with that fragment before he knew what to do with it. Whitmore Capital was not a name he recognized. He ran it through the Historical Society's records, through 3 databases of defunct corporate entities, and found almost nothing. One reference in a 1941 issue of the Galveston Daily News, a shipping manifest notation, and a footnote in a University of Texas doctoral thesis on Gulf Coast commercial banking. Whitmore Capital Partners, Est, 1928, dissolved or absorbed circa 1944. Principals unknown, no surviving corporate filings located, dissolved or absorbed. Those were different things. One was an ending. The other was a disappearance. The trunk had been in Clement Farrow's possession since 1963. It bore a transfer label from a Galveston shipping company dated September 1939. Someone had re-keyed the lock after manufacture. Someone had covered the original label with 2 subsequent ones, then lacquered the surface so that casual inspection found nothing worth investigating. Trunk 7 of 9. That meant 8 others had existed. Where they were was a question he set aside, for now. He took a Thursday off, drove to the Galveston County Clerk's Records Division, and asked for corporate filings from 1925 through 1950. The clerk, a woman named Adeze, who had seen stranger requests and was professionally unimpressed by all of them, brought him 3 archival boxes. The smell in that room was alkaline paper and cold air, and the specific dryness of documents untouched since the Carter administration. The temperature was 62 degrees. He found Whitmore Capital Partners in the second box, the Articles of Incorporation, filed 1928, a man named Raymond H. Whitmore, a man Douglas, a man named Douglas Farrow, and a third whose signature was legible, but whose printed name had been deliberately obscured, not faded, not damaged, but covered with a second sheet of paper clipped so precisely that Arden could still see the clip marks in the fiber after 80 years. Douglas Farrow, Clement's father. Arden photographed every page before the copy request was processed. Sometimes he had learned that documents in county offices sometimes developed a tendency to disappear between the request and the fulfillment. He drove back to Galveston with the re-keyed lock working in the back of his mind. He stopped at a hardware store and bought impression wax and a caliper. That evening, he took the trunk's lock, housing apart with a flathead screwdriver. 40 minutes, because whoever had installed the replacement mechanism had used a threadlocker compound set hard over decades. When the housing came free, he found, pressed flat against the back of the original lock plate and held there by the weight of the replacement installed over it, a folded piece of paper, not a letter, not a map. A list of numbers, formatted exactly like the column he had seen on the underside of the deepest label. Someone had hidden an index inside a lock that was itself hidden inside a replacement lock. Each layer of concealment had been designed to reward only the person patient enough to dismantle the previous one. The numbers were a catalogue. It took Arden 6 days to understand this. He had no formal training in trust administration, but he had spent 18 months handling estate papers, and the formatting nagged at him, not like a financial record, but like an inventory system. The kind used before standardized filing codes existed, when each trust's internal logic lived only in the mind of its administrator. He tested the theory by treating each number as a document reference and opening the trunk properly for the first time. Cotton gloves, with examination light camera, the smell was cedar and something older, the mistiness of organic binders breaking down over decades. The interior lining was intact, dark green moire fabric, slightly faded. The tray that should have held personal items had been removed and replaced with a false bottom, built not from plywood, but from quarter-inch oak panels with hand-cut dovetail joints, stained to match the original lining. Someone had built this with patience. Someone had built this to outlast them. Beneath the false bottom, 107 documents. He cross-referenced each against the numbered list over 3 days. Every document was present. Together they constituted the complete internal records of Whitmore Capital Partners from 1928 through 1943. Ledgers, correspondence, the original partnership certificates, and a series of instruments he did not immediately recognize. He photographed everything, then drove to see Gerald Obie, a retired securities attorney who now consulted for the Historical Society on estate documents. Obie looked at the instruments for 12 minutes without speaking. "These are bearer bond receipts," he said. "Issuance documentation, not the bonds themselves. 1938 and 39. He set them down. Beer bonds were abolished in 1982. But bonds issued before that date and never redeemed remain legally valid. The debt doesn't expire because the format does." "How much?" Arden said. Obie did the math on a yellow pad. "Between $4.5 and $6 million, depending on which federal court you're in." "That's not all of it," Arden said. He showed Obie the partnership certificates. Obie read the first one and stopped. Whitmore Capital Partners held a 43% ownership stake in Meridian Gulf Shipping, incorporated 1941. He set the paper down slowly. Meridian Gulf became Coastal Meridian Holdings in 1968. Coastal Meridian was acquired by Triton Logistics in 2004 for $780 million, Arden said. He had already looked this up. If that stake was never legally dissolved. "There's a document." Arden placed a single page on Obie's desk. A trust agreement dated October 1943, Raymond H. Whitmore transferring his partnership interest to a trust administered by Douglas Farrow, beneficiaries named as Farrow's lawful heir in perpetuity. The trust had never been. It had not been dissolved. It had not been forgotten. It had been made invisible. Outside Obie's window, a car door closed. Footsteps crossed concrete. Arden looked up, not from fear, but from the awareness of a man who now understood that what he was holding was worth considerably more than his own safety, and that he had not yet told anyone but Obie where he had found it. Garrett Lyle called on a Wednesday. Not Arden's number, the Historical Society's main line. Lyle had looked up the society. In the days since the will reading, someone had been watching what Arden did with his time. "I represent the Farrow estate," Lyle said. "The estate was distributed," Arden said. Questions have been raised about whether certain items transferred with the trunk may constitute assets improperly excluded from distribution. Lyle's voice was unhurried, the voice of a man who had never been in a room where urgency was necessary. "I'd like to arrange an inspection, purely procedural. I'll need to check my schedule," Arden said. After the call ended, he sat for 4 minutes without moving. The trunk was at his apartment. Lyle didn't know that. More importantly, Lyle didn't know what Arden knew about the trunk's contents. What Lyle knew, what someone had told him, was that there was a trunk and it might be worth something. That was the extent of it. The question was who had told him. The answer, Arden was fairly certain, was the third partner's heir. Whitmore Capital had 3 founding partners. 2 were dead. The third's name had been deliberately removed from the corporate filing in 1943. The same year, the trust was established. The only person with an interest in keeping that name invisible in the present was someone whose family stood to benefit from the partnership assets remaining unclaimed. Arden had not yet found that name. He needed 3 more days in the correspondence files. He had, however, already done the one thing that mattered most. 9 days ago, the morning after he understood what the partnership certificates meant, Arden had driven to the Galveston County Recorder's office and filed a claim of interest referencing the trust agreement, the partnership certificates, and the bearer bond issuance records. The filing was public record. The originals were in a fireproof sleeve in Gerald Obie's office. "He called, Lyle contacted me," Arden said. "They want an inspection." "Give it to them," Obie said. "Finish the correspondence cross-reference first. Find the name." "I'm not going to say anything to Lyle," Arden said. "I'm going to let him say things to me." The inspection was scheduled for a Tuesday at 2 in the afternoon. Lyle arrived with a woman named Sandra Crew, introduced as an estate documents specialist, who carried a soft leather bag and a manner that suggested she had been in many rooms where things were about to go badly for someone. She began photographing the documents before Arden said a word. "This is an informal inspection," Arden said. "Of course," Lyle said. He looked at the documents the way Brent Farrow had looked at the trunk, assessing something for disposal. "I'll need to tell you, as a courtesy, that the estate's other beneficiaries have retained counsel to contest the distribution. Their position is that certain financial instruments here constitute estate assets not properly valued at distribution, and that the will's reference to contents intact does not constitute legal transfer of instruments the beneficiaries were unaware of. The will specified the trunk and its contents," Arden said. "There are no conditions on that transfer. Courts have discretion in matters of undisclosed assets." Lyle picked up one of the partnership certificates. "We've also been in contact with Triton Logistics' legal team. They have significant interest in how any ownership claims are adjudicated." He set it down. "And there is the question of the trust agreement. It names Douglas Farrow as administrator. Farrow died in 1961 without a successor. Under Texas statute, a trust without a valid administrator is dormant and subject to escheatment." It was the argument Lyle had come to make. Arden had expected it for 4 days. "The trust names Douglas Farrow as administrator," Arden said. "It also names, as successor, the oldest surviving male heir of Douglas Farrow's bloodline at the time of any future claim. I had that language verified by a professor of Texas trust law at UT Austin. The clause is valid and enforceable." Lyle was quiet for 2 seconds. That interpretation would require a court ruling. It would. Arden opened a folder on the table and placed a document in front of Lyle, "Which is why, 9 days ago, I filed a claim of interest with the Galveston County Recorder's Office, referencing the trust agreement, the partnership certificates, and the bearer bond records. The filing was accepted and entered into the public record on that date." He placed a second document beside it. The originals are held by Gerald Obie in his capacity as legal consultant to the Galveston County Historical Society. Cree had stopped photographing. The expression on Lyle's face was not shock. It was recalculation, the look of a man who has entered a room with one set of variables and found that several have already been removed. "You did this before we contacted you," Lyle said. "The morning after I understood what the documents meant, the third partner." Lyle's voice had changed, but the unhurriedness was gone. "You identified the third partner. Raymond Whitmore," Arden said, "and a man named Conrad Sheely, whose name was removed from the original corporate filing in 1943, the same year the trust was established, and who was the principal beneficiary, and Whitmore died in when Whitmore died in 1951. He placed a third document on the table. Conrad Sheely's grandson is currently a senior partner at a commercial litigation firm in Houston. His name appears on the retaining agreement your office filed with the Beaumont Probate Court 2 weeks ago. The room was very quiet. "You came here to see whether I knew what I had," Arden said. "If I didn't, you could cloud the title or argue the trust was dormant. Either strategy would have worked." He picked up the trust agreement and returned it to the trunk. "But the filing is 9 days old. The originals are with counsel. The claim of interest is public record." Lyle said nothing. "You said I could have it appraised," Arden said. He closed the trunk. "I did." He walked them to the door. The litigation lasted 14 months. The Sheely family filed a challenge to the trust's succession clause in Harris County District Court and lost. They appealed. The appeals court upheld the original ruling in 11 pages, noting that the plaintiffs had taken no action to establish their own claim during the 8 decades those assets were recoverable, while the defendant had filed a valid claim within 9 days of the documents coming into his possession. Garrett Lyle was referred to the Texas State Bar's disciplinary committee for failing to disclose the conflict of interest. His firm had a pre-existing Sheely family dating to 2011, undisclosed at the Farrow estate proceedings. His license was suspended for 14 months. Brent Farrow filed a separate claim, arguing the partnership assets should be distributed across all of Clement's heirs. The trust language was specific. Brent received nothing additional. The bearer bond claims settled with the federal government for $4,316,000. The partnership ownership claim against Triton Logistics took longer. 43% of a shipping company traced through 2 name changes and 1 acquisition does not resolve to a clean number. What it resolved to, after 3 expert valuations, was $11,800,000, paid in exchange for a full release of ownership claims. Arden Farrow was 31 years old when the settlement documents were signed. He paid off his student loans, $31,400, in a single transfer. He bought a craftsman bungalow in Galveston's East End, built in 1912, with original hardwood floors and a small study that smelled of old wood. He left the Historical Society with 2 weeks' notice. He took a position consulting for 3 estate law firms, work that involved reading old documents in quiet rooms, which had always been what he was best at. The trunk sits in the study. He did not sell it. Gerald Obie, at the settlement celebration, asked him when he had known, when he had understood fully what he was looking at. Arden thought about it. "When I saw the lock had been replaced," he said. "The screw holes didn't match the impressions. Someone rekeyed a trunk they'd built to look worthless." He paused. "You don't protect something worthless." He had worked backward from there. The hidden label, the list pressed behind the lock plate, the false bottom, the catalogue of documents whose value took weeks to understand. No single moment of revelation, just one question answered, and another one waiting behind it, all the way to the end, There is a particular kind of intelligence that looks, from the outside, exactly like stubbornness. The kind that refuses to let go of a $14 trunk because the lock doesn't add up. The kind that files documents before anyone else knows there are documents worth filing. The kind that sits in a county records room until it finds the one footnote that changes everything. It does not look like intelligence from outside. It looks like a man who paid too much for a piece of old luggage. That is, of course, precisely the point.